I will also request my Vice President, Mr. Jatan Singh, to kindly have a seat. I welcome all of you. And our President would join us. So in the meantime, I will request Mr. Jatan Singh to present a plant to Justice Pratibha Singh.
I thought to narrate some poetry. Recite the poem.
Now I'll request Mr. Inderveer Singh Alar to present a plant to Mr. Hari Subramaniam.
Yogi, true politician.
Though the welcome address is to be given by the President, choose the topic and the speakers. Please.
Thank you, Sandeep. Good evening, all. I hope I'm loud and clear to all of you. Well, I start the evening with a quote of Mahatma Gandhi, who said, "Live as if you were to die tomorrow, learn as if you were to live forever." The initiative that the High Court Bar Association has taken is just to follow the philosophy of Mahatma Gandhi that there should be a continuous learning. And this is the whole concept behind that we started this chapter where we're calling it learning the law. It's actually the continuously learning of the law. And today's topic is a very interesting topic which is relevant to everyone, whether as consumer or manufacturer or a trader. Because consumer should not be cheated, the manufacturer should not be cheated, and the trader should not be cheated. And IPR deals with trademarks, designs, copyrights, and patents. We have two very fine speakers today with us. Justice Pratibha Singh requires no introduction. She has been at the helm of the IPR development of the law of IPR. And Mr. Hari Subramaniam has been a stalwart at patent laws. Let me introduce, I will just make a humble attempt to introduce Justice Pratibha Singh, who had finished a 5-year law with distinction and was selected and was given a scholarship for Cambridge. After completing that, she practiced in the Delhi High Court from 1991 onwards till she was elevated in May of 2017. She has been at the forefront of the development of the law, as I said earlier. I would also like to share very proudly that she had the distinction of being awarded as the 30 most powerful women in business by Business Today Group in 2018. She was designated as a senior in 2013, and she had a vast practice not only on IPR laws but on other laws, and she was a member of the IPR think tank, which was entrusted with the task of first IPR policy, which was released in 2015. So this is the background of the keynote speaker who will be sharing her rich experience with us in this chapter of IPR, which is known to many and not so much known to many of us. But this is a very fine field to start with our chapter on learning the law. I am just waiting for. Mr. Sandeep Sandeep, would you like to take over the mic for the time being? So, talking about the IPR laws, we have 4 aspects of IPR, which includes trademarks, patents, design, and copyright. Trademark is very well known to everyone. It is how a person gets his distinction for that product, and there should not be misrepresentation in the market. So to protect the consumer and the manufacturer, the law has been established, which has been changed from time to time, and it has been codified from 1940 onwards. I don't have much to say now. Can I invite now? Sir, President is still not there. I will invite Justice Pratibha Singh. On the right.
ये लो doyens of IP are walking in now. Doyen नहीं बोल रहा, doyen बोल रहा. लो जी, तालियां.
Our president is here. So he came at the right time. So I will now request the president to give the welcome address.
My apologies. Friday being a dancing TV day, so got stuck. Sorry. Today's topic, in fact, excites, and perhaps I'm the wrong person to speak anything regarding this topic, because I always felt that the lathis and knives neither fall under designs or patents or any trademark, and how to blow the real serious chapter to the Honorable Judge and Mr. Hari, doyens of the IPR.
DO बोला.
And they're watching, and I have today a Singapore attorney also amidst us. Welcome. So I welcome all of you, and thank you for encouraging the bar to carry on such activities in future. Thank you very much, and my apologies once again.
A very good evening to all of you. Mr. Mohit Mathur, Mr. Jatin Singh, Mr. Sandeep Sharma, all the members of the executive of the Delhi High Court Bar Association, senior counsels, most importantly, my colleague judges, Justice Tushar, Justice Banerjee, the members of the IP Bar, one of whom is my co-speaker, Mr. Hari Subramaniam, and all my colleagues from the Delhi High Court Bar Association, who are members of the bar, ladies and gentlemen. I must say, by starting, that I must have spoken in a large number of international and national seminars and conferences. But this is the most touching for me, because this is in my own home, that is the Delhi High Court Bar Association. And I'm really thankful to Mohit Mathur invited me to speak at the IPR seminar, which is the starting of the Learning the Law series. You know, in our country, we really don't have a continuing legal education. Like abroad, if you go to the US or any of most of the developed world, they have what are called the CLE programs, where every seminar you attend, you earn CLE points. And Where there are CLE points, you'll find a bigger audience. But today, this is without CLE points, and that's really nice that the seminar hall is full. I'm really thankful to each one of you for having come here and to learn about IP. I want to make this a little more interactive than what all of you would think, because of course you all speak the whole day and we listen to you the whole day. It's my turn to speak today, but I still want, especially the younger members of the bar, to come forward when I ask a question, when I give you an opportunity. Please stand up and give an answer so that it becomes more interactive. That way the learning is much better, and hopefully you'll go at least 5% wiser than you were when you came in by your own involvement in the program today. A lot of us wonder whether intellectual property rights are very, sophisticated, it's for the rich and not for the poor, and that kind of a feeling a lot of us may have. But let me tell you one thing, there is a need for intellectual property, and why? What is the need for intellectual property? Why do we need to have a law on intellectual property? The need is because it starts from, if you could say, the biblical principle, thou shalt not steal. So, if someone has created something, invented something, made something new, then one shouldn't steal it. It's like a very fundamental principle. And the second thing is that the person who's making it, or inventing, or creating, needs to have some encouragement. And creativity needs to be rewarded. And that is the reason why intellectual property law exists. And this law has expanded, and I can tell you one thing from my the kind of matters that were are very different from what it is today. Matters would be by a big MNC on one hand and a small company on the other hand. But now it's not like that. A large number of trademark matters which come are of Indian businesses, Indian startups, Indian medium enterprises, Indian companies who sue for protecting their own rights. So the way intellectual property is perceived in India has completely changed. So intellectual property is going to grow, and I guess that is the reason why they've chosen intellectual property as the subject for the learning of the law series. This I'm going to skip because there's a large history to it. I won't be able to cover it in a short time. Just to say that the earliest convention on intellectual property dates back to 1883, one of the oldest, and the earliest statute of monopolies was like even older. That's like 1600s. So there has been a large number of international agreements on intellectual property, and that's all that you need to know. Just to give a perspective of what is IPR. Do you know we actually live, breathe, and sleep IPR? Just imagine one thing. As soon as you wake up in the morning, what is it that you do? How many of you check your mobiles in the morning before brushing your teeth? See, that's a substantial number. So your phones are full of intellectual property. Your toothpaste has intellectual property on it, the brand that you use. The technology in the toothbrush, we've had cases on that. So that's like when you wake up in the morning. Then you have your food. Food has intellectual property. It has brand names, it has recipes, copyrights, it has geographical indications like basmati, it has Darjeeling tea. Everything that you eat has some form of intellectual property, whether it's a brand, whether it's a logo, whether it's a GI, whether it's a copyright. The clothes that you wear have intellectual property. Again, whether it's brands or designs or artistic copyrights. Plants have intellectual property. There is trade secrecy. There is any amount of intellectual property. When you get into your car, the car is full of technology. That's again intellectual property. The music that you listen to in the car has copyright. And until unless there's a compulsory licensing regime, which is there to make sure you can listen the FM radio, there is no songs in the car. So that's copyright. You use your laptop, that's full of intellectual property. The software, the hardware. When you come back home, you watch television. That is a broadcasting right. The television channels have broadcasting rights. You read books when you go to bed. How many of you read books, by the way? Still. Okay, that's good. Because a lot of us have stopped reading books. So, copyright in literary works. A lot of us listen to music. A lot of us watch films. They're all intellectual property. So, from morning to night, intellectual property is pervading our life without us actually realizing it. We just have to start realizing, and you will realize how IPR has a lot of contribution. Even the medicines that you eat have intellectual property. It's patented or branded or generic, either way. You know, it has intellectual property. So everything that you do from morning to night has intellectual property. And the only reason why we don't perceive it is because we don't pay attention. The minute you pay attention, you will realize that there is IPR in everything that you do. So these are the various forms of intellectual property. Patents, on which mostly Mr. Hari Subramaniam will be dealing with. We have copyrights. Copyrights are very, very vast. Copyright could be a painting, it could be a book, it could be software, it could be a database, it could be music, it could be artistic works, it could be a sculpture, it could be any kind of modern internet websites. They're all, even apps, everything has copyright. Copyright ranges from the oldest kind of creative works till the most modern creative works. Copyright Act, according to me, though a very brief act, is one of the most dynamic acts in our country in intellectual property. Can you imagine it's a 1957 act and gone through few amendments, but it is still holding the fort and holding good, even till date. It has not been amended in a very big way, the Copyright Act. But it's able to take care of all the developments in technology. Then you have industrial designs, which are meant for beautiful and aesthetic things. Plant varieties is for agriculture. Geographical indications is for, how many of you know what is geographical indications? Okay, who is the youngest? Someone here. Yes? You can tell me. What is a geographical indication?
You can take the mic.
I'm not required. Geographical indication is a product from a particular geographical location. It is generally like Darjeeling tea, which is coming up from Darjeeling and having a particular way in which it is
Yes.
produced.
You're right. Any other examples of geographical indication? Yes. Yes. Did you know Tirupati Laddu is a geographical indication?
Odisha's Rasgulla.
Yes.
Bengali.
There's a fight on Odisha and Bengal. So Justice Banerjee can have a fight with you.
No, it was decided.
It's decided? Okay.
Outside the
Do not take away Rasgulla from the Bengali.
So,
Never take a Rasgulla out of the mouth of a Bengali.
so I've just put up a lot of geographical indications for you. So they, as the gentleman here said, geographical indications are intellectual property that relate to a particular place. So it could be Kolhapuri slippers, Kanjipuram sarees, Banarsi sarees. It could be Channapatna dolls. It could be, India has such a rich, a vibrant culture that we can have. I think we have almost 400 or 500 GIs which are registered. So the GI doesn't belong to one person, it belongs to the whole community. So the community can protect it in the manner in which they deem it appropriate. So there are cases now where GIs have started coming to court. When I was on the IP division, I saw one of the first cases on a GI infringement action in our Delhi High Court. So we do have GIs which are protected. Let's come to trademarks now. Why would any of you buy a branded or a trademarked product versus a non-branded product?
Quality.
Who would like to answer this? Not the same person.
Quality.
Quality, yes.
Reputation in the market,
Yes,
financial security, that you're investing in the right product.
right. That's connected to quality, right?
Brand value.
Brand value. Yeah, you can say Shoshabazi also. I want to show off that I have a Hugo Boss t-shirt or a Louis Vuitton bag.
Bragging rights.
Bragging rights, that's what I said. That's just a English sophisticated way of saying it. Right. So brands have a lot of reasons. The highest being quality. And one knows that I can trust this product, I can buy it and I know it will be durable, it will not cause me any harm. I mean, why would anyone buy a branded, mixie or a food processor or those kind of things also, branded phones. So you know that they will last for a little time. They are capable of distinguishing between one product and the other. And brands could be different kinds of product. So let's look at, I'm going to ask you to give us a few examples. Give me a device brand. This is under 2M. Can someone give a device mark as a brand? Give an example. Apple? Yes.
Apple iPhone.
Any device that's a logo. So that could be a brand. There are a large number of logos. We just have a few of them here for you. Give me an example of a signature being a brand. Can someone think of a signature? Someone's signature. Ritu Bedi. I don't know if she has a signature. Gaurav Gupta, yes. I've done his cases are come. He's a designer. Johnny Walker. Any other signature? Sorry? Rohit Bal, does he use a signature? Okay. I think Amitabh Bachchan has registered his signature. Can someone do a numeral mark? Numeral number?
8 p.m.
555. 8 p.m. Pivot 5000. 3M.
24/7.
24/7. Can someone give a shape mark? A shape of a product. So the mark should not be there on the product. Just by the shape you can recognize the
Body circles.
Okay. Thumbs up? No. Montblanc is not shape of a product.
Mercedes Benz.
That's again a logo. That's again a logo. It is not the shape of the product. I'm asking that the shape of the product. Why don't you think of Polo Mint? What about Toblerone? Chocolates. So even if you see a Toblerone chocolate, even without the Toblerone, you will know it is a Toblerone. So these are shape marks which are registrable.
I think Vicks also.
Vicks, yes, the triangular. Can someone tell me a color combination?
Orange.
Orange, no, orange is a mark by itself.
Coke.
Without the word written on it, can you recognize a color combination? MasterCard? Tommy Hilfiger? Yes. Burberry? Good. So these are all the various kinds of marks that you can register in India. So in some countries, even a single color can be registered. But in India, there's a debate whether a single color can be registered. Normally, the Act only has a combination of colors, actually. So these are some of the examples which we wanted to give you. Now, what are the steps which go through in a trademark application? First of all, if a client comes to you with a mark, what would you do? What would you do? Correct. So first of all, you will search it and see if there is anything which is similar. Then you go to the trademark office website. You need to get an attorney code for that. Get an attorney code, file an application. Every word of that application you must read carefully. Don't file every application with a proposed to be used basis. question the client. Since when are you using? Go back to the earliest invoice, earliest advertisement, earliest adoption. Give the client the advice that you do not do it in a very, what do you say, mechanical manner. Do it with a lot of application of mind. So the application has to be very clear, the name of the entity has to be correct, the address has to be correct, give the email address, give the phone number, from when you're using the mark, give a clear representation of the mark, give a proper user affidavit with some documents. Nowadays, trademark applications, you get a result, I'm told, within 1 week itself. Is that correct?
Yes.
Within 1 week, it's examined. So just imagine if somebody in your neighborhood says, ma'am or sir, I want to register my mark, all you need to do is do a search, put the fee, get your attorney code, apply for the mark, and then you're through. Within a week, you will know whether your mark can be registered or not. But therefore, everything depends on the kind of application you file. In earlier times, I remember every mark used to be filed with proposed to be used basis. And those things will have a big impact when you come into court and seek an injunction. Because you will say, oh, I adopted it in this date, but your trademark application says proposed to be used. So now the division bench has held that if you say a wrong thing in the trademark office, you're bound by it. So it requires a lot of application of mind. Don't do it mechanically. So then it goes into the journal. And if someone comes and says, madam, I want to oppose this mark, sir, I want to oppose this mark, make sure that you look at the deadlines. The deadlines are absolutely not shakeable. You may lose your opportunity to oppose. And that may then go into registration and it will be a big complication for the client. So this particular thing is very important. The Trademark Act has lots of deadlines. Please be careful when you use, when you apply, and when you prosecute the mark. Suppose there is an examination report with some objections. I know that a lot of us have templates for replies. Please don't use templates. Make your reply, apply your mind. It's like drafting a written statement or drafting a plain. So even if it is short, 4 or 5 paragraphs, please make sure that all your points are going into it. Templated replies can create a lot of problem later. So don't make templated replies. Make them properly with the proper defense. Cite the right judgment so that tomorrow if you go before a judge, you have the right case law which has been cited in the reply which you file. And then there's the registration. Once there is a registration, you get the certified copy, give it to the client, get the legal proceeding certificate applied for, give that to the client. Please inform the client as to when he or she has to renew the mark. That is very important. Most people forget to renew the mark. Clients forget. And a lot of times what happens, the lawyer who has applied for it is no longer around or whatever has happened, the client also forgets and the mark may be lost. So please inform the client. And if you have a database within your own office, please maintain a database so that you can send a reminder to the client when you need to renew the mark. So this is a much more complex process. This I don't think we need to go into. These are the various forms you need to look at. So what does a trademark registration give you? It gives you the exclusive right to use the mark. It gives you the right to prevent others from using the mark or a similar mark. And you can also restrain people from using it for similar goods or services. And if the mark attains a good reputation, you can stop it even for non-identical goods and services. So can any of you give me 2 or 3 cases on non-identical goods and services? So I'll start by giving you the oldest example which we all think of is Mercedes Benz. Benz used for undergarments. It was injuncted by this court. Philips electronic products used for, I think, mattresses or foam was injuncted. Yes, can you give me some recent examples, please? Yes.
One example I remember is Somani. Somani is basically used for tiles, but in a judgment, the person was using Somani for water tanks. So the person who was using for water tanks has been injuncted.
Okay.
There's one question. Yahoo.
Yahoo for?
Yahoo was used for making underwears.
Just and I was for the defendant, I think, in that matter.
sir, that must be the feeling after wearing the underwear.
I told it was held to be descriptive.
Any other example?
One which is not injected
Yes.
is lux.
Sorry?
One which is not injected is lux for garments and amul for garments.
See, that has a lot of history. Yes. I think Abhilasha was saying.
There was bourgeois for cosmetics and a spa that ran under the same name.
Okay. Any other completely unrelated goods? Any of the senior?
Alkex is probably the furthest away. Oil and watches.
Okay. So there are, as you can see, there are large number of products for which you can injunct the use of a mark. Apart from the normal trademark registration, if your client's mark attains a particular reputation, you can also file an application to get it declared as a well-known trademark. So that's also a good thing. You should all know, you can see the procedure for that. And it helps the client in a very big way. Because the Supreme Court, I remember this is Justice Lahoti's judgment, which said that the court doesn't need to see the mark as it is today, but the court has to see it with a reasonable expansion, market expansion as well. So if you think that your client is today using it for cosmetics, tomorrow he could set up spas, he could set up garments. So that reasonable expansion can be taken into consideration as well. So that's how the scope of trademark rights is being expanded. So there is direct infringement, indirect infringement, then there's vicarious liability, there could be contributory infringement. These are a little complex and I don't think we have the time for that. So in trademark matters, what happens is ex parte injunction, then decree. In our court. This is what happens in 90% of the matters. But the three types of injunctions are obviously ex parte injunction, interim injunction, and permanent injunction. And I can tell you from my experience in the Delhi High Court, both as a lawyer and as a judge, that the reason why ex parte injunctions are very, very important, and Lakshmikant Patel says that, as much as we may take it lightly and laugh about it, it's very important because in a courtroom, there is a plaintiff, there is a defendant, and there's a judge. The judge doesn't need to see only the plaintiff and the defendant. The judge needs to see all the consumers who are standing outside who are not represented in the court. For example, whether it is in the case of counterfeit products, counterfeit food products, counterfeit medicines. I recall very clearly when my child was very young, I called the pediatrician one day and said, he prescribed a particular medicine. And I said, the fever is not coming down. So, the response actually hit me and I've never forgotten it till now. He said, ma'am, आप एक और chemist के पास जाके जहाँ bill मिलता है वहाँ ले लीजिए. And sure enough, I did that and the fever came down in एक evening. So, in medicines and food products, the court has to be so conscious of the consumer's rights, the patient's rights. So therefore, in trademark matters, as much as we think that it is about the plaintiff or the defendant, it is more about the public as well. It is in that sense kind of a public interested kind of litigation as well. Because if the consumer is consuming, counterfeit products or, bad coffee, I remember Mr. Hemant Singh keeps appearing in those Nestle matters. And those Nescafe coffee sachets, counterfeit sachets, just imagine. I mean, it may not even be coffee, it could be anything. I don't know what it is. And despite the fact that the courts feel repeatedly that, how long can a court hold the field? One is forced to do that because the court is thinking of somebody who is not represented before the court, and that's the public who is not there in IPR matters. Therefore, it's very important and to protect them, that the principles like delay doesn't matter, acquiescence doesn't matter, the principles are very broad to protect trademark owners. But now we move into a new era with the internet. Every well-known mark has a illegal domain name. Not only in India, across the world. Whenever we discuss with judges from across the world, the biggest challenge to intellectual property is the internet. And the internet is going to be, I think, more and more complex. And I keep saying there will be a day when we will see TRIPS 2.0. And that will be the internet. How to regulate the internet internationally. So we have rogue websites, we have cyber squatting, we have mirror websites, people taking away money on the basis of, you registering illegal domain names. And it is, I must say, one of the most challenging things that courts are facing nowadays. That is about how to enforce IP in the internet. And the Delhi High Court has been a leader, in fact, not just in India, but globally, on setting new precedents on internet and how to regulate it. I'm just going to show you a couple of cases. What's the time limit on this?
Just said that you keep listening to us. So we are just listening.
No, I don't want to do that. Okay, so. Correct. I think so. So, social media platforms, e-commerce websites, you order products and you realize when it comes to your house that it's not a real product. It's not a genuine product. And then there is all this law on intermediaries and whether the websites are responsible or not. It's a very highly debated and contested issue. But at the end of the day, consumer interest has also been kind of safeguarded by e-commerce websites, but also there is a problem of violation on the websites as well. So these are, you may be wondering how, suppose someone registers delhihighcourt1.com. I'm just taking an example. And that person is located in, say, Australia. And Delhi High Court today passes an injunction against that website. How do you think it's enforced? That order is not enforceable on an Australian company. Why do you think it is enforceable? Okay, first of all, do you think it's enforceable? How many of you say yes? How many of you say no? The majority seem to be saying neither yes nor no. Okay. So there is what is called the Uniform Dispute Resolution Policy. And I think this policy has been promulgated by what you call the international and connects three people. It connects the person who is registering the domain name. It connects the company which makes the domain name available. And it also tells both of them that if there is someone else who is an owner and a court passes an order or an arbitral tribunal passes an order, you have to implement it. So therefore, under UDRP, thousands and lakhs of cases have been decided where domain names are transferred to the real owner without geographical boundaries. It's according to me, when you think of it as a lawyer, it's like magic. It's the most successful dispute resolution mechanism till date. I mean, that's in my experience. And therefore, this is how domain names which are illegally registered can be given back to the rightful owner. And I would commend each one of you to read the UDRP. There are a large number of judgments. The Supreme Court judgment on this is Satyam Infoway, written by Justice Rumapal. All of you, please read that judgment. You will understand how the system works. It's a very well-written judgment. So now, what happened in India was, or in other world, suppose there's a cricket match that's going on, or a new movie being released on Friday. Thursday there's a screening, which is called a premiere, and Thursday evening it will be on your cable channel or it will be online. Before even the movie is released. So there was a time in the Delhi High Court that all of us judges would know which movie is being released by the case which would come on Wednesday. And some of us used to discuss as judges, no, we should have Shah Rukh Khan in court. We can't pass the injunction without him. So that's how prevalent these suits had become. And the Delhi High Court passed orders saying that the websites will be brought down. Not only that website, any other website which is also streaming that will be brought down. So if you injunct torrent, there will be a torrent 1, there will be a torrent 3, torrent 20. So then the Justice Manmohan's judgment on UTV, it gave the dynamic injunction which said during the currency of the sports match or match, while the match is going on, there would be more and more websites which would keep coming up. So the Honorable Court said that you can injunct all of those without a specific order of injunction. And these websites were blocked by DOT, through the DOT and the MEITY, that is the Ministry of Telecommunications. So this is the way in which piracy is actually being reduced in our country right now. And revenues for India, which is the biggest producer of creative works, whether it's music, films, folklore, songs, that's how it's being protected. Or it's content like sports and cricket matches or whatever. So this is one of the biggest challenge, and I think Mr. Sai Krishna was the lawyer in this matter, UTV, isn't it? Dynamic injunctions. So there was a difference of opinion internationally. I think which jurisdiction Mr. Sai Krishna didn't follow dynamic? UK didn't follow. So Singapore and Australia followed it. Right. So the Delhi High Court adopted dynamic injunction and said it's high time that. And Mr. Mohit Mathur will wonder, in criminal law, it's always against unknown people. In civil law, it is always against an identified person. But this dynamic injunction is kind of bringing the unknown person's concept into civil law. So it is that way a little strange, if you may ask. But technology, makes us do this. I keep saying technology and law is like a hare and tortoise race. So the hare is running, the technology is just running, and the law is just trying to keep pace. But as the tortoise won finally, so I think the law will also win one day. So this is about dynamic injunctions. There was another case of Ramdev versus Facebook. Now this is a bigger challenge that courts are facing because the laws in every country are not the same. For example, on defamation. Defamation is like, in India, we may be, some countries may be very sensitive. Some countries are in the middle. Some countries give free speech like on the other end of the spectrum. So the law is not the same. So there are contentions which are raised that we can only block a particular defamatory post only in India and not across the world. So these kind of issues are coming up, and that is in Swami Ramdev versus Facebook. This shows the jurisdictional conflict in the internet. Another case, in the case of copyrights, we've already covered what copyright means. It's interesting that in copyright, there is no opposition. It's the easiest way to register. So you can file an application in the Copyright Office, it will be examined and the certificate is issued. So as lawyers, we used to say, apply for the trademark and the logo also you apply for copyright as well, after getting a no objection, because copyright was a cognizable offense at that time, and it is still now. So copyright registration is easier. Okay, now before we go to the other case relating to copyright, I have two questions for all of you. This is a tattoo which has been copied.
Original expression of life.
Yes, but everybody draws tattoos. What is so original in it?
You can never 100% replicate it.
The medium of which it is expressed. It's a question of what kind of permission you have from the person who's letting you use this on their, for example, hand or wherever you are doing it. So it's like what right? Interplay will have to be balanced in deciding whether it's
Contract of service versus contract for service.
I like the civil lawyers in a copyright matter. So in this case, it was a nun who was exhibited with a cigarette and with a, I don't know which bottle it is, it's a wine or a whiskey bottle. And a very artistic and creative expression of a nun. Can you see that? Yeah. So it was held that there is a copyright. Suppose a monkey takes a photograph.
Not a person.
Why? How many of you think, suppose I'm using my camera and monkeys can replicate. So you can copy. Suppose
The owner of the monkey who trained the monkey.
Right. So in the case of a monkey, there's a US decision which holds that the monkey doesn't have a copyright for the photograph. So these are all the complexities that we face in copyright. Digital reproduction, it's easy to copy, click of a mouse, you can download, and I think all of you are aware of the challenges. So I'm going to skip this. This is an interesting case where, there's a teacher who used to make her course material. So the course material, there were a number of people who started Telegram channels disseminating the course material. So all the course material was made into PDF forms and they would charge 500 rupees for admitting anyone on the Telegram channel. They were making money. And the teacher came to court and said, I want Telegram to tell me who is running these channels. So Telegram then said, sorry, we have our server in Singapore, we are not bound to disclose to you. And that person who's running a channel has a right of privacy because of the GDPR, the latest European law on privacy and data protection. So we have a Singapore lawyer here. Okay, let's ask you, what do you think should be the answer? Should Telegram be asked to give us the information or no? You can stand up and answer if you wish.
Thank you. I think it depends on the platform laws in the country, right? And this is something that is up for debate. I think there was a series of hearings in the US as well, where Section 230 that grants immunity to platform owners and providers is up for
No,
debate.
here we are only asking for disclosure of the person, name of the person, or the identity of the person who's running the infringing channel. We are not asking Telegram to be responsible, no.
Right, but Telegram would probably claim some proprietary rights in that. So, but I think, in this case, probably Telegram should disclose. But if there's servers in Singapore, you have a hard time. So.
Okay, so there is a conflict of law issue here because Neetu Singh, the lady here, was a copyright teacher based in India. She rightly sued under 62(2) of the Copyright Act and said, I want to know. And this is English and other civil service coursework, civil service exams coursework. That has nothing to do with Singapore. Just the server is based in Singapore. So, under Singaporean law, this would have been infringement. And so a direction was given to Telegram to disclose the details. So they gave the mobile number of the person who was running it. And they accepted the judgment, which was the best thing that happened. That was really good because this is the only way that copyrights and laws can be protected if intermediaries cooperate only, not otherwise. So this was another challenging conflict of law issue. That we. So this is what it is. In patents, I'm going to touch about only one judgment mostly. See, patents, I think Hari Subramaniam will be speaking, so I'm not going to go into too much detail. You can have a patent for a new product or a new process, so long as it is industrially applicable. And there are certain things that are not patentable. If it's naturally occurring, if it's a discovery, if it's contrary to morality. So in this, I want to take you to two examples. What about an invention made by artificial intelligence? Should it have a patent? How many of you say yes? Please raise your hands.
I think in one foreign jurisdiction it has been recognized.
No, just think about it and raise your hands as to whether you think an AI invention should get a patent or not.
Madam, this was my question I was going to ask in the last.
Sorry, sir, I beat you to it. Yes. Can an artificial intelligence system invent something and can it get a patent? How many of you think yes? Please raise your hand.
In future, it might happen ultimately. Not today, but in future, it might happen.
It can happen now also. If I make a formulation and I do it through the ChatGPT, I say it is my finding. It is my intellectual property. It is my.
How many of you think no? It should not.
It should not. It must not.
So majority think no. There are more people. I'm not sure if it's majority. So, how many of you think cloning should be permitted? This is that dolly sheep. How many of you think that cloning should be permitted and patented?
It has already been permitted when Anand Chakravarti patented the Suprabhat. This is how the life patent started in the USA.
In India, how many of you think cloning should be patented? Okay. So, the first judgment in the whole world, from what I know, is this case of Stephen Thaler. So, Stephen Thaler made a system called Creativity Machine. And this machine came out with an invention. He applied for patents in different jurisdictions. The Australian Patent Office granted the patent. The UK Patent Office did not grant it. In India, it is under objections. So the question is whether the patent ought to be granted or not. The Australian patent finally in the federal court got rejected. And even in the UK, it has got rejected right till the UK Supreme Court as of December 23. The intention being that the AI cannot itself be an inventor. AI can only be a tool, like any software or hardware. The inventor always has to be a human being. And therefore, the purpose of intellectual property law is to reward human creativity, not machine creativity. So as of today, the law is that AI patents are not permissible, but I'm not so sure how long this will stand, because most of the molecules in the pharmaceutical industry are currently, AI is being used to kind of identify a bunch of molecules, and then there may be further clinical trials and research. But we don't know how long this could go on. There could be a day where AI can become an inventor or a copyright owner, because AI can write better music than the human. Like, for example, I remember someone told me that there was an AI program which was asked to analyze all the Jagjit Singh songs or the Javed Akhtar lyrics and to create a new song, so that the AI came out with a new song. But the answer to that was, AI can only check on what is existing, but Javed Akhtar has all his unwritten, the undisclosed songs still with him. So copyright is still for human creativity and not for machines. So there's a very big debate in the world currently, and I think all of you are going to see this debate over the next 20-30 years. So I'm going to skip the remaining slides on patents, and anyone wants to do patent searching, these are the databases. Just thought we'll give you an example of what are the databases, where you can do research on databases. Most of them are free. Only the advanced databases are on subscription. So I'm now coming to the last few slides. IPR is civil litigation and it's civil commercial litigation. As you all know, it's governed by the CPC and the Commercial Courts Act. And in our court, it's also governed by the IPD rules and the patent rules. But there are certain things that IPD is doing which is helping in expediting the disposal of cases. I can tell you as a matter of fact that last year in the Delhi High Court, we had 1,350 cases filed in the Delhi High Court on the IP division, which has 2 exclusive judges, and the disposal is 1,350. It's 50 more than the filing. So if you combine the Delhi High Court filing and the commercial courts filing in the district courts, the annual filing is more than 2,000 cases a year. And the disposal on trademarks, I can tell you, is like 90% disposal within 2 years. It's so high. And one of the biggest reasons for this is also our mediation centers. Our mediation centers are doing really amazing work on mediating IP disputes. I got out statistics, and you won't believe, even during the COVID-19 pandemic, in some of the months, the disposal was 100% in IPR matters. So it just shows that the bar, the litigants, and the whole ecosystem is so vibrant and robust that there is more filing, more disposal. The more disposal that's happening, there is more filing. So it's like a loop. And some of the reasons for that is that the IP bar is an excellent bar. They, in earlier times, I could remember we used to have some lawyers who would take territorial jurisdiction as the first objection, and we would say outside court, you can't take this objection. There is an unwritten pact in the Delhi High Court not to take such an objection. So these are you could say vibrant practices, the amiability with which the IP bar functions. Admission denial happens on affidavits. Joint schedules are filed. Our original side rules are implemented on the IP matters very strictly. If anyone keeps trying to take adjournments, there's cost which is put. There's summary procedure which can be used under Order 13A and Order 15, case management. In some cases where we feel that the defendant is acting funny, we even call them and record their statements under Order 10, which helps. Nowadays, in most IPR matters, there are enough costs being awarded, damages being awarded, and therefore, I really think that we have created a very vibrant ecosystem in the Delhi High Court for IP. So it is I'm having some practical tips for you at the end. It's a very highly competitive field. It's absolutely cutthroat. Mistakes could have very serious consequences because there are deadlines. The client won't even bother, he'll just move from you to another lawyer. So you have to be careful with the work you do. You have to be tech savvy in IP. Without computers, without internet, without cloud servers being used, without you knowing how to bookmark files, you won't be able to file IP matters. So you need to learn all of that, have your softwares, and mind you, not the pirated ones. Get the subscriptions for the softwares. One thing that really helped me as a lawyer was to read business newspapers. At least one business newspaper, whether you read it online, read either Economic Times, Financial Times, or Business Standard, or one of those, business newspapers. Because I recall there was one client who would come to me one day and wanted to discuss a trademark matter, and I told them, oh, so how's your joint venture going with this person, with this entity? And they were just surprised because that was just a 2-day news, 2-day-old news. It was in the papers, and they were happy that, these kinds of things when you do with clients, they know that they are with someone safe, someone who's completely, on the roll, and they know that it's someone who's updated. So read business newspapers every day. The IP bar and the IP general ecosystem has a lot of women. So women are really doing very well in this field of law. So there's nothing for the girls also to think that whether it's a good field or not. It's one of the best fields to be in IP. And as I said, technology is the biggest help for you. And I must tell you one thing. We all wonder that when a person has become successful, oh my God, this is a known person, inka to hona hi tha, ye to naam hai, and all that. But I'll tell you, when I became independent, I didn't have a single IPR case. Not a single client. Almost 2 years. And what made me keep abreast was, I used to make head notes for patent and trademark cases, that is the PTC. And I used to do it free of cost. Never lost hope, never felt frustrated. Keep reading, be at it, and there'll be one lucky chance that you'll get, and that's your breakthrough. So don't feel sad that you don't have an IPR client. Just when you're free in the High Court, go and sit in any court, not just IPR, just to learn the tricks of the trade of all the senior counsels who are here, how they handle a court, how they plead, how they argue. You learn so much. Just by being around, you get the work. It is not because only you're networked or something. Nobody is networked in the initial days of your life. No one has networks. You build your network by writing, by reading, and by working hard. I'll tell you, in law, as much as we all speak about work-life balance, none of us have it. None of them have it. Till date, it's been 30 years in the profession. We all work as hard as we did initially, even to today. And that's what keeps us all going. And thank you for coming here in so many numbers. I see all the youngsters sitting on the staircases, which is very nice. And thank you for listening to me patiently. Thank you again for inviting me. This is the best seminar I have ever attended. It means a lot to me. Thank you.
Thank you, ma'am, for a very enlightening and a very interactive session. But not only 5%, I think we'll go wiser much more than that. Thank you. Now the youngsters can move up. There are some empty seats now. Can come up. May I request Mr. Mohit Mathur, our President, to present a memento to Justice Pratibha Singh. Done. Brother.
Yeah. Like that.
Thank you, Mohit. I now introduce Mr. Hari Subramaniam. I'm not going to take too long to introduce him. Our only thing that I can say is that we are all very proud of him. He's the first Indian to be selected and elected as the Indian president of the APAA. And it's a great achievement that anyone has achieved. And he has about more than 40 years of experience in patent laws. May I invite Hari now to give us a presentation, please.
Thank you, Mr. Alag. I may be the international president of Asian Patent Attorneys Association, but I must confess that I just happened to be at the right time at the right place. It could have been Mr. Praveen Anand who actually brought APA into India. And we are grateful to him for bringing such a wonderful association to India, along with Police of the International Association. And you may not know this, Justice Pratibha Singh was one of the founder members of APAA. And she was also the past president and the first woman president of APAA from India. So, Mr. Mohit Mathur, Mr. Sandeep Sharma, Mr. Chetan, Mr. Indrabir Alag, Justice Pratibha Singh, the lordships who are present here, senior advocates, my colleagues, all the youngsters who are present here. I echo Justice Pratibha Singh's sentiments for being here and for more, for inviting me here, because it's absolutely a brilliant forum. I've spoken in many forums, I've spoken in many places about IP law, about patents law, but I've not seen this kind of an audience, and in India, in Delhi, in an auditorium like this. It's absolutely beautiful. I wish Justice Pratibha Singh had continued speaking. I would have been delighted to sit there and hear her speech forever. It was so beautiful, it was so good. You should have taken my time as well. Yeah. I will keep it very short. Since Justice Pratibha Singh covered most of the aspects of IPR today, makes my job easy. makes it very, very simple for me. I'm going to confine myself only to patents, but that's what I do most in my life. I've been in practice for 40 years, and that's what I've been doing. You know, when you talk about IPR, everybody talks about patents, trademarks, copyright, and design. Seems pretty complicated, very, very complicated, but really it's not. But before that, something that Justice touched upon, why an IPR? What is an IPR? Everybody believes that you have, a lot of people believe that you must have an IPR to be able to do something. IPR really does not give you a right to do something, it's a negative right. It's a legal right to prevent others from copying what you have. Ownership of an IPR only gives you a right to prevent, like I said. The right to use your own IPR is not automatic. It will depend upon a lot of factors. It will depend upon a lot of other laws as well. Like having an aircraft, for instance, does not give you automatic right to fly. Owning a house does not give an automatic right for you to start a factory in it. But owning those can certainly give you a right to prevent others from even touching them. So how does IPR really help us, help any one of us? This is something self-explanatory cartoon. All of us have experienced this. I've been on either side, both sides, several times. And it's well, that comes with this question. Am I copying? Am I cheating? Is this a difference? So the question that always arises is, in this particular situation, the expression of the guy on the right side, well, left actually, it's very clear. He doesn't like other guy copying his work. The expression is very, very self-explanatory. But does that mean copying is not permitted here? What's the difference? We saw a tattoo of a nun smoking. This is evidently not a nun. And we know that smoking is not illegal unless we smoke in a prohibited place. If I smoked inside a courtroom, I don't think I'll ever practice again after that. But we know that nothing is illegal unless it's prohibited by the law, even copying. So we have to remember that copying is a norm. Today, I could have listened to Justice Pratibha Singh's presentation and tried to speak like her tomorrow. I will not be violating any copyright. But if I use the presentation exactly the way she did, I would be. So we need to identify the difference. Now, very similar to what Justice said, it is normally very human for all of us, normal for all of us to safeguard what belongs to us. It's equally human nature to steal or get free of cost things that belong to others, right? Things of value. This is one of the cartoons. I've seen a lot of cartoons on IPR. There was this guy in the state of Illinois, in his farm, he had a very old refrigerator, stopped working. He had to get rid of it. So, getting rid of an old refrigerator in the US is not easy. You got to have it incinerated. You have to have it transported to a particular site, and that would have cost him $500. He just wanted to get it away, throw it away, and you can't just dump it there. So he left it outside his yard, outside his gate. He left it for a week. Nobody touched it except pigeons. He just remained there. So then his lawyer, lawyers always give brilliant ideas. His lawyer gave him an idea. He said, why don't you put the sign there? Refrigerator for sale, US dollars 300, outside his gate. Next day, it got stolen. So that's what IPR is about. The moment there is something of value, there will be 50 people who will be trying to steal that away. That's why the protection becomes so important. Now, there was this, so therefore, there's always this need, it was always felt that one should be able to use what rightfully belongs to one without the fear of it being stolen. Now, when it's a real property, mobile property, immobile property, it's easy. You can lock them up. But when things comes from mind and then you let it out, how do you prevent others from copying? There are hundreds of stories about how IPR even originated. One of the lovely ones that I read ages ago in an Italian magazine was about this little dish which was being served to the Emperor Nero. It was called ova melita. It was called the honeyed egg. It had this particular recipe. Okay. Now, the emperor loved this stuff for breakfast until his cook, who was about 8 years old, fell very sick. And those days, when you fall sick, you didn't go to a doctor, you went to the seaside. Take a holiday, go away for a couple of months and come back. So this old cook, about 8 years old, was given a holiday to go. The emperor put a condition on him. He says, look, I'm going to have a substitute cook. You are going to share the recipe with the new cook. And this old cook said, no, I'm not going to do that. If I did that, what is the guarantee you are going to get me back? And I've been here for ages. You've been paying me a huge salary. Now this guy is the kid who's going to come back. You are going to get the ova melito made by him on my recipe. You are also going to pay him 1/10 of the salary that you are paying him. Then I become completely redundant. What do I do? Cook said, all right, give him the recipe, I'll give you some money. He says, no, I want to come back. After negotiation, the cook agreed to say that, all right, you give him the recipe. When you are perfectly okay, you come back, I get your job back. I'm also going to give you a lump sum. I'm also going to make sure that I'll give you 1% of the salary of the new cook to you, even when you're not working here. One of the oldest recorded stories of a patent, lump sum payment and royalty and licensing. And ova melita, like I said, anybody know what that is? Like the British love to correct anything they cannot pronounce. Ova melita is what we know as omelette today. Except that ova melita means honey. It was sweet then. And there's a change, that's an improvement. So let's just ask ourselves a question. Ova melita with honey was granted a patent. Can I come and change the recipe and make it a savory, get a patent? We'll examine that later. That's an improvement, right? Now, patent, unlike trademark or copyright, cannot go for a very long time. Trademark can be in perpetuity. Copyright has got limited period, but a very, very long term. Patent has a monopoly right only for 20 years. Given by the government for only an invention which is new and inventive. I'll explain what is that. Not in the public domain, not obvious. Jugaad you can't patent. Those of you watch 3 Idiots. Patent this guy, Kunchuk Wangdu, I think. He had more than 400 patents. I mean, Indian Patent Office must be really commended to be able to do that, grant 400 patents so quickly within a matter of 2 years. So, 400 patents, but you look at most of the machines that you are using, patented machines, most of them would not be really granted a patent in real life, they're all jugads. For a technology, any area of technology, not expressly prohibited by the law.
Yes.
That's the most important thing. You cannot be rewarded. So, patent is a reward to you for inventing and making the invention available to public. And in return, the government gives you a right to have a monopoly right for 20 years from the date of filing, so that you can really capitalize on your invention. So it's a question of quid pro quo. And there are certain conditions that everything that is invented cannot be patented. Things which are illegal, things which are immoral, things which are occurring in nature, simple and mixture. Just as Pratibha Singh gave you a whole lot of that. Some of these I'll go back on that later, explain on those. The question of something immoral, I'll come to that, that's very interesting later, because what's immoral? That's very contextual. Things occurring in nature. So what the law says is that our law does not prescribe, does not define what is an invention. Law only says what is a patentable invention. Law only says what is an invention. Something that's new, and not obvious. And it also gives you a list of inventions which cannot be given a patent. So anything that's an invention but does not fall under the category of unpatentable invention would be a patentable invention. Unlike in the US, somebody from the audience talked about this super microbe. It was a Pseudomonas species, a bacteria. This bacteria was genetically mutated by the gentleman called Dr. Chakravarti, the professor at Illinois University. The mutated bacteria could eat up oil spills completely in no time, which a normal bacteria did not have that capacity. The US Patent Office rejected the patent application on the ground that anything that's living is not patentable. The US Supreme Court reversed it, saying that once it's novel and inventive, everything under the sun is patentable. But not in India, not in Europe, not in many countries, there are exceptions to monopoly. We have well-defined patent ineligible subject matter. Now, one of the certain requirements for getting a patent is that your patent application must fully disclose the invention. Like I said, quid pro quo. Once your patent expires, it has to go to the public domain, and the public should benefit from the new technology. The idea is to ensure that the invention does not die with the inventors. It comes out. We have so much of traditional knowledge, which are all becoming extinct today because they were never protected, the families died out, and we don't have that traditional knowledge today. To enable inventions to come out, to encourage inventions, encourage new technologies to come out, government grants you inventions patent for 20 years, and after 20 years, it becomes also the public domain. And for that purpose, it's very, very crucial that your invention is very well described in your patent document. And you have a set of claims for monopoly sort. Again, I cannot unfortunately go into that. That's a huge amount of jurisprudence on that, what a claim is, but I do not have the time for that today. We have very strict deadlines under the Patents Act. Under the Patents Act, if you miss some deadlines, you are dead. You cannot get the patent back. Although in one of the landmark judgment in a writ jurisdiction, Justice Pratibha M Singh passed an order that when the deadline is missed by the negligence of the lawyer or an attorney, the court could, in exceptional circumstances, still not let the patent lapse and not penalize the inventor, but still get a patent. So applicant should not be made to suffer and lose valuable rights because of the negligence of a patent agent or a lawyer. One of the beautiful things that's happened over here is the establishment of the IPD, the Intellectual Property Division, of the architect of and the brain of IPD, sitting right amongst us here in this in the dais, Justice Pratibha Singh. And because of that, I still remember until 5 years ago when I had to rely upon a case law. I had to go through jurisprudence from UK, USA, Europe, elsewhere. In the last 2.5, 3 years that IPD has been in function in India today, it's unbelievable the number of precedents that we have, not only for India, these are being reported and quoted in judgments and quoted in the courts all across the world. And this is despite the fact that we, any given time, we only have 2 judges or 3 judges in the IP division. The enormous volume of the cases that have to go through, the incredible amount of technical information that to digest and hand on some fantastic judgments is not something, these are dreams are made of, and we have it. Which doesn't give an example of a very simple invention. This is an aspirin, this is an inhaler. An ordinary inhaler for asthma. The top over there, this top over here, this is a cap. This is the bottom vessel. You can remove the cap. Under this layer, there's a tiny, tiny reservoir where you put a capsule of the medicine. And at the bottom, there's a hole. You twist the cap, the top of the capsule is cut off, and then during asthma, if you have asthma, you breathe through the mouthpiece here. The idea is for the medicine to come inside your lungs. The only other alternative was to actually take tablets. And those of your chemistry background will understand that to have a 2 milligram of tablet, 2 milligram of medicine delivered to your lung, you need to have about 50, 60, 100 milligrams of the tablet because it goes to every part of the body and you can have side effects. So the purpose of this inhaler was to deliver powdered medicament into your lungs. And it worked beautifully, except that the patient needed an asthma. Because when a person is suffering from high asthma, for which this is meant for, and the person is trying to breathe through this, sometimes, the breathing is not controlled. They breathe something very heavily, like that, and too much of medicine goes inside, and you start coughing. And then asthma gets worse. While the medicine was perfect, while the laboratory conditions, the device worked beautifully, the problem was when the patient needed it, it didn't work. So there was always this is old case, 1972. There were a lot of research going on how to overcome this objection. There were no other medicines. How to overcome this problem? How do I deliver medicine to the lung without a problem? This inventor realized that there's a huge column of medicine when you breathe that goes into your lungs, more than what is required. So walking through the streets of San Francisco, he saw wind blowing and some dust being picked up. And when the dust starts swirling, it becomes like an inverted cone. The top of the cone is very, very sharp, and the base of the cone is the dust swirls like this and becomes sharper and sharper. What a brainwave. He said, look, why don't I try to extrapolate that into this inhaler? All he did was, instead of having a little hole over there, he made that hole into a semicircular slit. And here, presto, when we took a breath, the air went inside this, it automatically started swirling. And the amount of medicine that was delivered was just the right amount. A simple invention, which still seems so simple in hindsight, so simple because that's how the air blows all over the place, that's what air picks up dust. He extrapolated that teaching into this. Now, there was an objection by the patent office, the objection by the defendants in the court of law, saying that it's obvious. What is there in the shape of a hole? But then, that's a hindsight knowledge. Was it really obvious? Was it so jugaad? There was no prior art, there was no document which showed this, which addressed this problem, which showed this particular device with this configuration. But was it obvious? And all the courts all over the world held that it wasn't obvious. So you could use scientific knowledge, extrapolate that, and still create an invention. Millions. Subsequently, that was replaced by the powdered medicament was replaced by globules and got a patent. Amazing things. Look at this. This is during my time. When I was a kid, we didn't have a toothpaste with plastic toothpaste. It all used to be aluminium. I still remember my mother used to, after you finish the toothpaste, she would cut the toothpaste, open the foil, there still be some toothpaste. And after that, she would put a needle, the suey inside the neck, and then give us toothpaste. So, and those who didn't do that would be wasting about 10% of the toothpaste. This little kid from the school, he called it squeezy tweezy. You just push it inside the toothpaste and push it right across. And till the last of the toothpaste would be pushed through this. He tried to get a patent for this. He never got a patent. Because in spite of it being so useful, it wasn't considered an invention. It was a jugaad. It was something that's just a workshop improvement. Yet Colgate gave money and took it from them. They put it as a free gift in their toothbrush boxes, covered the cost by reducing the amount of toothpaste by 10%. But still, the users got the complete toothpaste till the end, and they're just able to use more. So it was a win-win situation for everybody. It actually boosted Colgate's sale by 37%. Heart. This little portion, this is called the dorsal aorta. This is the ventricle from where the blood, purified blood, flows into the body. Here west you have a valve. So the valve, human valve also suffers. The principle of valve is that the blood has to go in one direction, not the opposite direction. Now there are artificial valves like this. So many of them, and they were all granted patent. Simple things like, look, this is a bottle, you can turn it upside down, the sauce won't fall off. Patent there again. This is an amazing patent, probably come to a market somewhere, where the human body acts as an interface between two computer stations, because he has got some sensors and chips embedded in his shoulder. So he becomes a human computer. We don't know whether the technology will ever work or not, but there's a pattern for this. Do you know what this called? What we call here in India? You use that in Holi. It's called Pichkari. It got some amazing patent all over the world and sales were incredible. Spandex, Sarah Blakeslee made billions of this by this body-fitting fabric. Beanie Babies, all of us who have got small children, we have all used this. Coca-Cola can. The inventor of the Coca-Cola can did not license, did not sell his patent. He was not just one of those next door person. He made this invention while behind. The famous cola was, Pepsi and Coke, they were fighting with each other. The bottles will disappear. You will find all kinds of strange things coming into the bottles. Bottles will be reused with a cockroach in it. Sometimes there will be air in it. Sometimes there will be spider in it. Everything was happening. When the lions were fighting, this little inventor comes and creates a tamper-proof can, one-time use. He licensed it to Coca-Cola for 1 cent per can. And he made more money for 20 years than all the directors of Coca-Cola company put together. So you don't have to be very rich to have an invention and make money from this. From safety pin to space rocket, there's absolutely no limit. This, a simple calculator, calculating machine, like in school we had an abacus. This gentleman called Herman Walbrecht invented it. In 1911, he sold it for $1 million to a company called Computing Tabulating Recording Company, who used to sell meat, cheese, and scales of tabulation. That is the primary goods which they were selling were meat and cheese. Later, it was structured into IBM, computing giant. Anyone know this? Anyone has heard of Tokyo Chushin Kinkyo? I can't even pronounce it. And this is a rice cooker. First ever rice cooker, 1945. And it did not sell, and it's a Japanese inventor. It did not sell in Japan because the quality was very high. But it sold like crazy in China. And they made incredible amount of money. With that money, they moved over. This company was started by a contractor and a naval lieutenant. And then they slightly moved to little telecommunication engineering equipment. And then they made a little more money, patented every one of them. And then this is Sony as we know today. Their first product was a rice cooker. So imagine what the power of technology, power of invention, power of patenting is. You have a monopoly right, you have incredible ability to use this. Justice Pratibha Singh also talked about inventions not patentable, section 3D. Section 3D is something, it's a flesh in my bone. Bone in my flesh, sorry. It's but at the same time, it's very, very important for the Indian economy. Section 3D says an incremental invention or a new form of a known compound cannot be patented unless you have significant increase in the therapeutic efficacy. I'll come to that judgment where it came from. This was a compound called propyl methoxy propyl allyloxane. This compound was invented for curing AIDS by Gilead. And patent was granted for this everywhere in the world. In India, you didn't get a patent at that time, we didn't have product patent regime. While in the laboratory, in a test tube, it completely eliminated the virus. In human body, it could kill only 45% of virus. The problem was that the HIV, the virus, is very, very specific to a very special blood cells, T4 cells. And to deliver this medicine just to those bunch of blood cells, you needed about 1000 mg of the tablet 4 times a day. So therefore this would not, so to have 1000 mg 4 times a day in the human body meant that the person would die of the medicine and not AIDS. So it wasn't such a commercially viable thing. So you could use this with a 45% kill rate of the virus just to enable the person to have a slightly prolonged life of a couple of 2 years, but never. The same compound was then modified into a carbamate form. If you see its OH group, the two hydrogen atoms here have been replaced by this part. This is called a compound, carbamate. Now, this compound, what's called bisphosphonates PMPH, the carbamate form of propyl methoxyphosphodinosine, is not a drug. It doesn't have any efficacy. But when you ingest this tablet, 25 mg, it goes into your stomach, cuts through your stomach wall, goes straight into the blood. So reduces the amount of medicine that you got to take. 95% of the medicine goes into the bloodstream and straight away kills 90% of the virus. Patent was not granted for this by the Indian Patent Office, in spite of the fact that patent was granted for this in every other country of the world. Because in India it was said that this does not have an efficacy. It does not have more efficacy than this. The point is, when you give to the patient, this works better. It saves them. This doesn't. But this medicine by itself, because the Supreme Court judgment will come to that later, says that it got a therapeutic efficacy in the cellular and molecular form. We went on an appeal before the appellate board. Unfortunately, the appellate board was completely dysfunctional, and by the time the matter could ever come up, never came up, the appellate board was dissolved, and the term of the patent died. It got over. Now what is? This is a famous case. Nobody knows this case better than Justice Pratibha Singh. She created history on this case, the case in the Supreme Court, which clarified the purpose of Section 3D. Imagine miscellate. If you look at this compound and look at this compound, it's exactly the same, except the folding over here. This is a beta crystalline form, a specific kind of crystal of the same compound. This medicine is for juvenile cancer, blood cancer, leukemia. This was okay, but it wasn't really approved by the government. This had been approved, got a patent for that. It increased the bioavailability in the mouth, the oral bioavailability by 20%. The question was, does that mean, although it works better, does that mean it increases the efficacy, or is it only a property, inherent property? And the Supreme Court held that this is not a therapeutic efficacy and cannot be granted a patent. We'll skip this. This is a case where M Singh and Mamta have been very deeply involved in. Valsartan. It's a compound that's very well used for blood pressure. Now, blood pressure is the multifaceted compound. It starts from the kidney, it starts from the liver, it starts from various places. When you have something called angiotensin 2, when the body creates angiotensin 2, you get blood pressure. So you have to prevent formation of that. Valsartan, a patented drug of Novartis, helped in doing that. Except that it did not work in all the cases, because they discovered that the blood pressure could come from, the angiotensin 2 come from various parts of the body, kidney, liver, heart, everywhere, lung. It was combined with another compound called sacubitril, which prevented the formation of something called the neutral endopeptidase. When you combine the two, 2 plus 2 wasn't 4, it was 8, and patent was granted, although it was opposed very heavily by various parties. This is the case of Hemant, and I've been involved in this matter for many years. This patent for a simple sulfur compound, a sulfur admixture for fertilizer, with a very specific granular size, very specific particle size, resulting in a very special advantage of instantaneous dispersion and absorbability conversion into sulfate. Only formin plant can take this. This has 7 pre-grant oppositions before the patent office, 2 appeals, 1 review, 2 writs, 6 post-grant oppositions, and patent was granted, and now it is facing 5 revocation proceedings. That is something that's a problem in the Indian patent law. Sometimes an inventor has to go through more amount of Agni Pariksha than standard. Because many a time under Indian system, the inventor has to be really put through rigors of IP to defend his case all the time. Because of a bail under the patents law is a pre-grant opposition is open-ended, it can be done all the time. And the person who can file a pre-grant opposition, if has locus and he can file a post-grant, then he can, So how is it that a person can have 2 shots on the same matter? Why doesn't this duty get applied? That's a thought for all of us. This is another famous case, meat. Those of who eat meat, I earlier showed that morality, invention, anything that's immoral cannot be patented. This is a case which I handled in several jurisdictions. Those of you who eat meat know that, that the imported meat, when you put in a cold storage, when you cook meat and you eat it, it is no longer tender. It becomes hard sometimes, in spite of the fact that the quality of meat is very good. And when you consume it, it's not. The problem was that when the animal is butchered and the meat is transported from one place to other, it undergoes several changes in temperature. First it's put in a freezer, then it's put in a flight, it's lying in the customs, then offloaded from the aircraft, then put in a truck, then comes home, various places temperature keeps changing. By the time it reaches the consumer or the hotel, it's pretty bad, tough. The inventor discovered that while the animal is still alive, hang it upside down and inject it with a hormone and then split it like this. The animal is actually hanging from its legs there, and it takes 8 hours to die. And it's like writhing in agony and pain. And finally, when the meat is taken, you could transport it. 3 months later, you eat it, it melts like a mouth like cheese. Now, question arose, was it patentable? Indian Patent Office straight away said, no, it's immoral. The European Patent Office, the New Zealand Patent Office, and the Australian Patent Office, they wrote an issue. They formulated an issue. Let's see, is it immoral or is it, really does it have a commercial gain? Everybody agreed what the animal goes through. Everybody agreed that animal goes through incredible pain. Everybody agreed that meat at the end of the day is super. The European Patent Office, under the term order morales, said that the suffering caused to the animal far exceeds the commercial gain, and therefore it's immoral. Australian and New Zealand Patent Office said that the commercial gains far exceed the suffering caused to the animal, and therefore it's perfectly moral. It's like half a cup of water, is it half full or half empty? The question is the same, issue is the same, the consideration is the same, yet you can have completely two opposing judgments. This is the last case I will go because I know that you're conscious of time. And this is a lovely case where I acted as an expert witness before the Kansas City Court. The language of a claim. Unfortunately, we didn't have a judgment because it became a compromise judgment later in confidential terms. Now, here it was air purifier. So when you have air purifier, the purpose of air purifier is to allow pure air to come inside the room, which means that it should prevent all the contaminants from entering the room. The problem with all that, so they have a rotor is coated with silica gel, and when the air passes through that, it goes to the rotor, comes inside the room. The problem with the prior art inhaler was that the known air purifier was that it would not only prevent the contaminants from entering the room, but also moisture. As a result, the air that came inside the room was very, very dry. So the inventor found that this was his invention. He says this was the main part of his claim, characterized in that the rotor is coated with an absorbs the contaminant, having a pore of about 3 micrometers. 3 micrometers angstrom is 1,000th of a millimeter, such that it allows water molecules to pass through but not any contaminant. Patent was granted. And one of our clients was sued in the US for infringement because he exported exactly this air purifier, except that the pore size was 3.5 micrometer. The question that came before the court was that whether the term about 3 micrometer, that covers 3.5 micrometer. The patentee argued, mine is not 3, mine is about 3. So approximately. The defendant said, no, 3.5 micrometer is huge compared to 3. Therefore, I am not infringing. The court's simple question was, what is the important purpose of the term about? And the court considered what should about 3 micrometer mean, and we have to give technical evidence, and I gave that also. The court gave us a guidance. Give the meaning in the context of the claim. It should allow water molecules to pass through and not any contaminant. So the pore size should be such that it should be close to 3. It should stop contaminants from coming in, but not water. So the next question was, what is the size of water? Water was 2.8. So the court said it should allow water molecule about 3 would mean even 2.8. 2.7 will not allow water molecule to come through, but 2.8 would. So about 3 on the lower value would be 2.8. What's the upper value? It should not allow any contaminant to pass through. The closest contaminant in the environment was ammonia and methane, the size of which was 3.39, 3.4, and the defendants was 3.45. It was considered non-infringing. So, science is beautiful sometimes. The evidence that we need, everything is so important, and of course the courts have to interpret the claim in the context of all the prior art material in front of them and deliver judgments. Thank you very much for this patient hearing. And of course, I know that you don't have much time, but if there are any questions, I can take. And if I can't answer the questions, this is the message. You could answer every question.
Thank you, Hari. May I request our patent attorney from Singapore, Abhimanyu Singh, to please step forward. And Jatan, the proud father, present a memento to Mr. Hari Subramaniam.
उनको बोलना
Thank you, Abhimanyu. Thank you, Jatan. If anyone has any questions, we'll take the questions some other time. Today we're running out of time. I'd like to request our Vice President, the expert at vote of thanks, to come forward and give his vote of thanks.
There is no meaning of having a lecture. It is a one-sided story.
I think there cannot be a better inaugural of the lecture series by having the galaxy of speakers and the people those who are day and night quoted in the quotes. And this is Pratibha and Mr. Hari Subramaniam. Thank you so much for this is our inaugural lecture series. We are today inaugurating and starting this. And the audience today is marvelous. The hall was overflowing and there was no space to sit. Thank you all. I would like to thank some of the biggies of this subject have gone, but Mr. Hemant Singh, yesterday I spoke to him. He was busy today, but I said, Mr. Subramaniam and Justice Pratibha, they are coming, and I must thank you especially. And Mamta also. I thank Mr. J.S. Bakshi, sitting all through senior advocate. So many senior advocates have gone, Mr. Anand, Mr. Chandralal, Mr. Diwan, and I must not thank enough Mr. Sai Krishna, who is the guru of my son. All the ladies, sitting, Rajdeepa, Anjana ji, Shilpa ji, so, and always there, Vinasha is always there in all our functions. Thank you so much for coming. And I thank all the younger members. My friend Virender is sitting. One of a very old friend of Mr. Mohit Mathur, and I saw it after so much of time. Rajiv Chauhan was here. Mr. Giri is there. So everyone, thank you so much for coming. And for all these two great people, I have one couplet to say. Otherwise, my vote of thanks would be incomplete. जो चल रहा है उसके पाँव में Oh yes, I thought Mr. Mohit Mathur said कि हमारा तो जो क्रिमिनल साइड में मुके का और उसका मैं आपको बता दूं अभी थोड़ी देर में जब तक गदर 3 आएगी तो 2.5 किलो का हाथ और जो हैंड पंप वो भी होने वाला है अभी रजिस्टर्ड सो जो चल रहा है उसके पाँव में जरूर छाला होगा मतलब जो लोग इतने हाइट तक पहुंचे हैं वो चले जरूर हैं जो चल रहा है उसके पाँव में जरूर छाला होगा बिना संघर्ष के चमक नहीं मिलती This is for our speakers those who are masters of their field जो जल रहा है तिल तिल जो जल रहा है तिल तिल उसी दिए में उजाला होगा Thank you so much for coming and please join us for a cup of tea.
There's only one more thing I want to tell you before we leave. We're going to have the next session on 22nd March. Yeah. Topic we'll decide.